But that leads us to our big debate topic of tonight, where I may have unfortunately another contrarian and controversial position concerning birthright citizenship.
So Trump signs an executive order ending birthright citizenship, which is the idea that a child born in America of illegal non-entrant parents does not get granted American citizenship, which is going to face legal challenges. And a great many people are predicting that the executive order will get struck down as being unconstitutional because the Constitution provides that I don't know, what is it, a natural born citizen? Anyone born on American soil, whether it's of children of foreign invaders, although maybe there's an exception to that, children of slaves who were not recognized as citizens, are American citizens. I presume that's where you're going with your position on this, that Trump's executive order will get struck down as being unconstitutional?
A federal court has already enjoined it. Now, whether it's right or wrong, we'll get to. So first, let me try to strongman the Trump argument. So the professor, if you want to read some good articles on this, read Professor John Eastman, who advocates for Trump's position. Stephen Miller does as well. A range of legal scholars have. So I don't want anybody coming out with the impression the media sometimes tries to relay that this is that this is beyond controversy, question, or debate. It is absolutely not. The big question is the language subject to the jurisdiction in the 14th Amendment to the U.S. Constitution. So it says anybody born in the United States and subject to the jurisdiction thereof is a U.S. citizen. Question is, what does that second phrase mean? We all know what born in the U.S. means. Mm-hmm. What does subject to the jurisdiction mean? Now, Eastman and others would argue that subject to the jurisdiction is based on a Lockean concept of consent, which is that citizenship, it gives as much as it takes in its modern form. In other words, you get rights that come with citizenship, not just obligations. I'll get to later why that actually matters in terms of interpretation of these provisions. And that at the time the 14th Amendment was passed, the entire focus, historical focus, was on overturning Dred Scott and restoring the right of slaves and their descendants to be citizens. And in particular, it was an argument that a national citizenship existed independent of and separate from state citizenship. What the Supreme Court decided in Dred Scott was that states couldn't give citizenship to ex-slaves or the descendants of slaves. And that it gave us the Civil War, was the idiocy of the Supreme Court of the United States and their corruption, because many of them were connected to the Southern planter class, busy lining their own pockets. So there's no question. So from a historical perspective, looking at the Eastman perspective, subject to the jurisdiction, the language of that is subject to debate. So let's go back and look at the historical context.
If I may interject, I can imagine diplomats, but maybe that's different because if they're born in a what's the word for a diplomat's office? An embassy. If someone's born in an embassy, they're not subject to the jurisdiction thereof, but are they even technically on American soil?
That's a separate argument. So This all goes back to jus soli, jurisdiction based on the soil, versus jurisdiction based on Saint Graal or something like that, based on the blood. So the Eastman argument is that the Lockean concept is the only thing that legitimates government is consent, and that the American Revolution was premised and predicated on that idea that it's because I consent to government, the social contract theory, that government has any legitimate authority over me, or that I have any obligation to it, or it has any obligation to me. And the argument is that so that subject to the jurisdiction is a broad exclusion of anyone born in the United States who, for any reason, is not consenting to being part of the United States as a citizen, or the U.S. is not consenting to their being having any obligations to that individual. Now, as you point out, it's undisputed that certain people were excluded. One category was anybody who was excluded from jurisdiction based on their parents being diplomats. That's diplomatic immunity. The second category, more broadly, were anybody who was part of an Indian tribe who might be within territory the United States claimed, but was primarily subject to Indian tribal jurisdiction. Tribes had various treaties with the United States that governed it, but the tribes did not consider the United States in control of their tribal territory. And so in recognition and respect of that, They excluded those. Now, not all Indians, by the way. Just those Indians were the ones excluded. That's, by the way, where the legal language "Indians not taxed" comes from. Indians not taxed is referring to a group of Indians outside of U.S. jurisdiction, because by recognition of the reality that they're not taxed. If an Indian was taxed, an Indian wasn't living on a tribal reservation or tribal territory, then they were subject to U.S. jurisdiction and could be U.S. citizens. So I've seen some misrepresentation that all Native Americans, that's not the case. But the theory that Eastman and others advocate is, at a minimum, there was the anchor baby problem was not a problem of that generation. So we don't know whether they would have interpreted subject to the jurisdiction from an originalist perspective as excluding the sons and daughters of illegal aliens born on U.S. territory. They argue that subject to the jurisdiction language logically leads to a broader exclusion of anyone who doesn't fit the Lockean consensual model of citizenship under the social contract theory of interpreting U.S. constitutional law. So that's the snap. It gets into much more detail and much more. There's arguments about. I should add one third category. It was undisputed historically that someone who came in as part of an invading army was also not a citizen of that country, because they're not subject to the jurisdiction, because the invading army is in control, not the country that previously existed. So those are the three, foreign diplomats, Indians living on tribal reservations, not taxed, and people that are part of invading armies. Undisputed that their just so lie does not equal birthright citizenship. The question is, does it go further and say that, in fact, there has to be some form of consensual proof, like the naturalization process, or by blood, that you could be a U.S. citizen by blood, that one of your parents you inherited it as a matter of ancestry, and that's another theory of power. There's reasons to be worried about going down the blood route, but I'll get to that in a second. But so you combine those theories, and there's many competent, capable legal scholars that support President Trump's announcement that he was not going to recognize citizenship to those who were born to illegals who had not yet been naturalized in the United States.
And if just to pause you there, because a lot of people have this, not to say misconception, but they have the idealized conception that this is like, illegal immigrants who have been here for years, paying taxes, jobs, yada, yada, have families. There's an industry to this. Like Alex Jones was talking about it, and I've known about it as well. Chinese illegals, Chinese people come, people from China, the People's Republic of China come when they're pregnant, specifically to have babies on American soil. A known confirmed element of this.
There's people who market it as a business. They say, we can help you get you set up, we can get you here, so you can have your kid here, and then you have U.S. citizenship. And then the secondary problem that concerns a lot of people on the right, especially, is that the child, once they're U.S. citizen, is guaranteed a whole bunch of benefits that in turn allows their parents to stay here illegally. And not only to stay here illegally, get U.S. benefits, get U.S. jobs, get U.S. welfare benefits, get health care, get schooling, get food stamps. That's their concern. So it's a legitimate concern, understandable, very respectful scholars on that side. Now, let me give you the contrary argument. Historically, the theory of citizenship, the doctrine of citizenship, never thought of itself as empowering individuals. Most of our law, Anglo-Saxon law of the jurisdiction, comes from wanting power over people. So it was governments, and because of that, the legal history of interpreting the word subject to the jurisdiction were very broad. They didn't see it. The courts weren't sitting there saying, golly gee, does this person really have rights he can enforce against us? Almost never. It was, do we have rights we can enforce against him? Can we take his property? Can we tax him? Can we draft him? Can we do all these things? So for that historical reason, the legal interpretation of subject to the jurisdiction was very broad. It was assumed you were subject to the jurisdiction unless you fit a narrow exempt group. Like, okay, we acknowledge if you're here as part of a foreign emissary that you are not subject to the jurisdiction as part of diplomatic immunity or the invading army, or you're actually part of another community that we have legal control over the borders of, but not within, like Indians not taxed or tribes, not members of tribes and not taxed. So, and I can tell you historically, the better argument is all on that side. there is Eastman does a fantastic job. Others do as good a job as you can. But I've dug into this issue in great depth. The overwhelming, because of that historical phenomenon I just talked about, all the law goes against us. The 1898 Supreme Court decision strongly implies that the sons and daughters of people who are not U.S. citizens, who are Chinese, were U.S. citizens because they were born on the soil. It's strong. I mean, I get there's ways to interpret and try to extrapolate. It's just, and if you understand the politics of the time, that very conservative, or the conservative in like a corporatist way, Supreme Court, that very establishment-oriented Supreme Court, was all for Chinese immigrants being here because it was lining their pockets in their investment in railroad companies, for example, because it was the so-called coolies, the Chinese immigrants working those railroads that made those railroads as profitable as they were. So if you dig into if you're a true originalist, which means you care about what people thought at the time that constitutional amendment was passed, which means the priority is not on the people who wrote it, but on the people who passed it, which means looking at the votes and the public opinion that supported it. Oh, by the way, it overwhelmingly suggests that subject to the jurisdiction is a very narrow exception, not a broad exception. To give you some examples, this came up. Gypsies, the infamous gypsies, present throughout the United States. This came up during the Senate debate. People are like, the gypsies are not citizens, or if their kids are born here, are they? And everybody saw the gypsies, controversially so, but they see them as this way. Saw them as moochers, saw them as thieves and criminals and whatnot. It's just a very common colloquial.
It's where the expression "you got gypped" comes from. It's someone screwed you out of something, sold you something crappy. It's because they got gypped because they were gypsies. It's an offensive term.
Exactly. There's another offensive term that a friend of mine once said, and she's like, "Oh, I wonder if that's offensive." She's like, whenever I try to do a negotiation deal, my dad taught me to try to Jew them down. And I was like, yes, that could be offensive. You be very careful. There's some people that will take pride in that phrase, but there's plenty of people that will not. But yeah, so that's the history. I'm not greenlighting the history of this negative history of gypsies, saying it's accurate or anything like that. I think it's much more complicated history. But it's just to give you an idea. That was the public perception at the time. They debated whether the son and already Chinese immigrants were here. They could not be U.S. citizens. By the way, they had loyalty to foreign powers. Like this one theory out there says, if you also have loyalty to a foreign power, you can't be U.S. citizen. That makes no sense because U.S. has recognized dual and triple citizens forever. So that's just never been the case. The historical argument is weak from, again, an originalist perspective. If you want to eliminate the originalist perspective and you want to do a living constitutional perspective, then you have a much better argument. But then you're embracing the left's theory of law. Mm-hmm. And think long and hard about whether you really want to do that.
Well, someone over on Rumble, also above average, says, "Can they draft you?" And although I know that you believe the draft is unconstitutional, but if they can draft you, you're subject to their jurisdiction. So the child born here can be drafted.
Yes, and there's an argument about that, about how that works and how that process is. But yes, the theories of subject to the jurisdiction is that if you are subject to the king's jurisdiction, they can take your property, they can take your freedom, they can take your liberty, they can take everything. And that's how they see it. And that's why the law was written the way it was. Now, it is true that today you could make an argument there's been a seismic shift in the perception of citizenship, that citizenship is no longer about what you owe the state, but what the state owes you. And in a participatory democracy creates a whole different animal because now they can vote and control the government. So one of the arguments I had with libertarians who are saying, hey, look, we shouldn't have any restriction on H-1B visas or anything like that. I was like, on immigration, because we should have a global labor supply because it's the most affordable, most accessible, best market, free market, et cetera. And like the problem is, what happens when the free market comes with a political tax? Like all of a sudden, you have to give these people voting rights so they can control you in the future. You could recruit you could bring in a bunch of people who are socialist at heart. And all of a sudden, in the name of the free market, you bring in all these immigrants, and all the immigrants suddenly decide to create a socialist government. This has actually happened in certain respects around the world over time. So I get there's good argument. Eastman is as good as anybody. Good historical arguments that from a living constitutional perspective, I think if you, this is where I get a kick out of the left. The left is all arguing original jurisdiction. They all of a sudden don't want living constitution.
Oh no, Robert, all of a sudden the left loves sworn statements. Elizabeth Warren relying on sworn statements of perjury, but they don't like it when it's a Varys report of an adverse event from the jibby jab.
Exactly. So my own view is that where the Supreme Court is likely to rule, because it's ruled this way in the past, because it reflects the broader history, you're going to get all the liberals against Trump. All you need is two. You need two of this corporate centrist, two of the three corporatists, or two or a combination of that and the conservatives. I think you'll get a couple of conservatives who go with Trump, but I think that's going to be it.
And there's no
is likely to rule that subject to the jurisdiction includes those who are born to citizens whose parents were not citizens of the United States, unless those. Now, the one caveat component is Trump is exploring pursuing an alternative theory that doesn't say birthright, that there's never birthright citizenship, but rather that those who were part of an invading army, the invaders of the Biden administration, that they're not entitled to it as an invading army analogy. And he actually cited that provision of the Constitution for curtailing invasions as part of his authority for this executive order. I think that's an interesting argument. I don't think it's one the courts are likely to accept at this point because of the legal history. Because the problem is this: the liberals who believe in a living constitution are never going to go along with Trump on birthright citizenship. The conservatives who believe in originalism know that originalism doesn't support Trump's position when you dig into it. I mean, there's arguments. I'm not saying there's no argument for it. I'm just saying the best arguments really don't. It's very hard to get there. My own view is very simple solution. There is broad public support for limiting birthright citizenship to those whose parents have shown a commitment to be part of the United States at some level. Their resident visas, they have some legally recognized basis to be in the U.S. other than as a diplomatic entree or as a tribal member. I think that there's enough support to amend the Constitution to clarify that. Why do I support Article 5? Because the path to illegal immigrant reform. Because I care about originalism in the Constitution. I refuse to abandon it just because I don't like the political and public policy consequences of the originalist interpretation of the 14th Amendment. But I'm not going to pretend that the history under the 14th Amendment supports my political cause when the best evidence says it doesn't.
Well, Robert, the real good news for Trump is that we now know you can amend the Constitution by way of a tweet. So all Trump has to do is tweet out, "It is now law of the land," and thus is amended. Article 14?
Article 5 is the amendment to amend the Constitution. The 14th Amendment is the one that provides the citizenship.
Yeah.
And so there is a good historical argument that that they didn't consider anything in this scale. I think the best argument is a version of the invasion argument and the argument that philosophically we have shifted. Citizenship is no longer obligation like it was in medieval days where these terminologies originated, where the words just soli come from.
Yeah,
citizenship is power, not obligation. There's some obligation, but not as much. And so I think that shift recognizes a shift in perspective. But the best way to respect that shift is to amend the Constitution through Article 5, not let judicial fiat amend the Constitution.
Well, or they deem it to be an invasion. They deem illegals, to be an invading force. And
there's a circumstance where you could do that. I don't want that abused too much because there's risks to saying, okay, I'm just doing my invasion power, and all of a sudden our civil liberties are stripped from us. But that's my view. I don't think Trump is going to win before the U.S. Supreme Court. I think Trump knows this. He knows it. But I think it's smart politics. You lay out the executive order, let the courts enjoin it, show the public that the courts say the current Constitution doesn't allow this executive order, so we need to amend it and make it a political issue in every campaign. I want to change Article 5 so the only people who are citizens of America, the only people who get to vote in America, are those who have taken the requisite steps to show their loyalty to America. And that the sons and daughters of illegals who haven't done anything to do so, other than being born, haven't done enough to show their loyalty to America, and that should be the condition of citizenship, given that it affords and provides as much as it takes away.
Let me read this here.
That needs to be by Article 5, not by changing the Constitution by executive or judicial fiat.
SJDG says, how much of Trump's push on birthright citizenship is aimed to push the amendment? We just got that. And this one here, Robert, before the 14th was accepted, it was argued by Howard that foreigners and aliens were excluded. HR 127. Barnes is wrong.
There's two problems there. One, to be honest with you, that's a dishonest interpretation of that. The conservatives have made that argument multiple times. If you read the whole record, it doesn't support it. It just doesn't. And I get conservatives don't like the consequence currently to the 14th Amendment. So they want to do a living constitution, but don't want to admit they're doing that. So all of a sudden they want to say, you know whose opinion matters? Only one senator's. Not the rest of the senators, not the rest of Congress, not the state legislatures, not the American public, not the long legal history of how that doctrine was interpreted. No, this one senator, because he says a quote that I like. You're engaging in liberal legal jurisdiction. You're being very selective about which quotes you take. and you're using them conveniently when they contradict all the language. By the way, what does he say in that context? He's talking about a specific subset. And they're pretending that when he's saying, hey, look, don't worry, the sons and daughters of foreign emissaries don't get automatic citizenship under this, then the nature of it is such that they're pretending, oh, no, what he really meant was to say all aliens, all foreigners were all excluded. Well, that's directly contradicted by the rest of the congressional record you're choosing to ignore because you don't like it. Don't become a liberal because you don't like the outcomes of an originalist conservative interpretation. Stick with the originalist conservative interpretation and instead follow the Constitution and the founders that said when something's not working, use Article 5 to fix it. Article 5 is the tool to fix it, not newfound, not lying about the history, not being selective about the history, not being a living constitutionalist, because those three steps make you a liberal on the court, not a conservative, not a constitutionalist.